When is it ever okay to reject the defense's settlement offer? Would you like to know the answer? Come join me near the marina as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. It is acceptable to reject the defense's offer when you, the injured patient, the injured client, believe that the settlement offer that you are being given does not correlate with the true value of your injuries. Now, there's a lot that goes into that particular statement. You could immediately, upon hearing of any settlement offer, you could turn around and say, no, I'm rejecting that. Now, any time a settlement offer is made, it is your attorney's obligation to actually have a detailed conversation with you about the risks associated with accepting the offer. Yes, there are risks with doing that. The risks of rejecting that offer, as well as the benefits, as well as any alternatives that might be present. What are some of the risks of rejecting the offer? Well, you might not get another offer. The defense attorney may have told your lawyer that this is the only offer you're going to get. In that instance, now you have to make a conscious decision, an educated decision about what you're going to do. Are you going to accept the offer even though you'd believe that it's not an appropriate offer? Knowing full well that the defense has told your lawyer that they will not make any additional offer? In that instance, now you have to make a decision. Are you willing to go to trial and risk what's behind door number one, which means go to a jury and have a jury ultimately decide what is the true value of your injuries, assuming, of course, that the jury sides in your favor, assuming that the jury determines in a malpractice case that your doctor was careless, that he violated the basic standards of medical care, and that his carelessness was a cause of your injury. So assuming all that, now the jury will ultimately have to answer what is the value, the true value of your injuries and all of the damages that you are claiming that you suffered. And you are hoping that the jury recognizes that the injuries that you suffered are far in excess of whatever it was that the defense had initially offered you that you rejected. That is the hope and expectation. But you should know something very important. There is no guarantee whatsoever. You may think you have the best case in the world. You may think you have the most severe injuries ever. But the jury may not see the true value of your injuries. The jury may think that your injuries are worth less than what you perceive them to be. On the other hand, the jury could come back and give you significantly more money than what you asked for or what you perceive your injuries are worth. In which case, that means you've just bought yourself an appeal, which means the defense will most certainly go ahead and appeal the decision, and there could be any number of consequences. I say consequences because there are any time you go ahead and take a verdict, and now the defense is going to appeal. On an appeal, the appellate court, the higher court, has many different options available to them as to what they are going to do. Are they going to leave the verdict as it is? Are they going to reduce the verdict? Are they going to increase the verdict? Are they going to turn around and say, you know what? None of this makes any sense. We're going to send your case back down for a trial on damages. And now you have to try the case all over again. So there are many different outcomes that can occur when your case actually goes up on appeal. So you have to answer the question, is this the appropriate settlement offer for me? And if it's not, you should turn around and say, of course it's not. However, there may come a time where your attorney is in negotiations with the defense, and they make an offer that is so attractive, that is so full of incentives, that it's almost impossible for you to say, no, I'm not taking this. Why? Because they may come back and give you almost everything that you are asking for. In which case, again, if they don't give you every single thing that you are asking for, top dollar, full value, again, you have to have this conversation with your attorney. Can you live with the alternative? Can you live with the possibility that you reject this offer, don't get another dime from the defense voluntarily, go to trial, a jury comes back and now tells you, sorry, we don't believe you have a valid case? That can happen. And you might turn around and say, how is that possible? I have a great expert and now there's no possible way we could lose this case. Well, I will tell you, you are wrong. Why is that? Because anytime you go to trial, and now are relying 6 members of the community in order to determine whether you are slightly more likely right than wrong. You have no idea what the jury is ultimately going to do. You don't know how well your witnesses will perform at trial. You don't know what the defense has dug up on our experts. You don't know what's going to happen with the defense witnesses. The jury may not like you. The jury may think that you are being less than truthful. And so, although you may feel you have a great case, although you may have the best expert in the world who supports your position, there may be some underlying issue where the jury turns around and says, sorry, we don't believe you have a valid case. At which point, now you will be out of any money that the defense has offered as a settlement. You will have no option other than possibly having to try and appeal, assuming there are legal grounds to do so. So you have to have that conversation with your attorney about the risks, the benefits, and certainly the alternatives of rejecting a particular offer. So why do I share this great information with you? I share it with you just to open your eyes, to help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and, importantly, you have not yet started a lawsuit and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.